Good afternoon. Hey, Colonel, you want to roll your window down?
No.
Why not?
Why are you detaining me?
I'm not detaining you, Colonel. I'm stopping you for doing 63 miles an hour in a 40-mile-an-hour zone.
The window, take her out.
I need your driver's license, your insurance, and your registration.
Do you have proof of the speed?
Yes, I do. It's on my radar, ma'am.
May I see it?
No, you may not.
The window, take her out.
What is your badge number, sir?
1721. It's my permanent ID number.
And your name?
Deputy McKenzie. It's right here, ma'am.
The window, take her out.
It's the Lieutenant Colonel. I had her doing 73 down there, and then in the 40, I had her doing 63. She sat at the green turn signal, and she's refusing to roll her window down or provide any documentation. And I figured, why not get you here before I rip her out of a car?
The window, take her out.
Yes.
Are you going to roll your window down all the way?
Now, can you hear me?
Can't. Problem.
I don't know. Your officer stopped me, and he won't let me see the radar.
You stopped first. Well, if you want to see the radar, you have to step out of the vehicle so you can see it. It's not a handheld device.
I don't have to step out of the
You do by Florida law. So I'm not going to argue with you. What's going to happen is you're either going to roll the window down and cooperate from here on out,
What are you detaining me
or
for?
right now you're impeding an investigation
I'm investigating for what?
for a traffic violation.
What was the traffic violation?
I already
Speeding.
explained to you, ma'am. You're doing
Okay,
63 in a 40-mile-an-hour construction zone.
I'm just going to tell you what's going to happen. So either you cooperate from here on out, or we're going to break the window and pull you out of the vehicle and you're going to go to jail. Yes or no? Are you prepared to spend the rest of the night in jail? Huh?
Based on-
Okay, break the window and take her out.
Hey, that's last in my car! Hey!
Before we get into this, drop your location in the comments. Where are you watching from? And if you're new here, follow right now, because this is the kind of content we break down every single week. All right, let's get into it. It was 12:26 in the morning on February 25th, 2025, when Deputy McKenzie's radar locked onto a vehicle doing 63 miles per hour in a posted 40-mile-per-hour zone. A 23-mile-per-hour overage that, under Florida Statute 316.187, constitutes a moving violation serious enough to warrant immediate traffic enforcement. The body cam timestamp doesn't lie, neither does the radar. McKenzie pulled behind the vehicle, activated his lights, and initiated what should have been a routine stop. What followed was anything but routine. When McKenzie approached the driver's window, the woman behind the wheel sat stone-faced and rigid. She was wearing a U.S. Air Force uniform, adorned with the rank of colonel, a rank that carries enormous weight within the walls of a military installation. But they weren't on a military installation. They were on a Florida county road, where the only authority that matters belongs to the sheriff's department. McKenzie identified himself, remained calm, and stated clearly on his own body cam he was stopping her for doing 63 miles an hour. No aggression, no theatrics, just facts. Her response was silence and a posture of contempt that telegraphed from the very first second that she had no intention of cooperating. She never rolled the window all the way down. She cracked it, barely enough to be heard, and seemed to believe that this positioned her on some kind of legal high ground. It did not. Under Florida Statute 322.15, any person operating a motor vehicle on a public road is required to present their driver's license upon demand of a law enforcement officer during a lawful stop. Florida Statute 316.645 further requires compliance with an officer's lawful orders. There is no asterisk. There is no clause that reads, "unless you outrank him." The window cracking behavior is a tactic that circulates in certain online communities, the idea being that a driver cannot be compelled to fully engage if they keep a physical barrier between themselves and the officer. Courts have consistently rejected this logic. The stop itself was lawful, initiated by a documented moving violation. The moment Deputy McKenzie activated those lights, a lawful detention began, and with it came a set of legal obligations that applied to her as a civilian motorist, regardless of her military credentials. Her smug refusal to lower the window wasn't an exercise of rights. It was the first in a cascading series of decisions that turned a speeding ticket into an arrest. At some point during the stop, she demanded proof. She wanted to see the radar reading. It is a request that sounds reasonable on the surface and has been romanticized by countless viral videos and social media accounts that frame it as some clever checkmate move against law enforcement. It isn't. There is no law in Florida or in any other U.S. state that requires an officer to produce a radar display to a motorist on the side of the road before issuing a citation or continuing a lawful detention. The radar gun is an instrument of evidence, not a court exhibit that must be previewed at the scene. Deputy Mackenzie had already clocked her speed, logged it, and had every legal authority to proceed. The evidentiary challenge to that reading happens in a courtroom, in front of a judge, with proper discovery and due process, not on the shoulder of a county road at midnight. The demand to see the radar was a stall tactic dressed up as a legal argument. Mackenzie didn't take the bait. He continued doing his job, professionally and lawfully, while she continued doing hers, which at this point appeared to be seeing how far she could push the encounter before something broke. She asked for a supervisor. That request, in isolation, is entirely within her rights. Any person detained by law enforcement may request the presence of a supervisor, and that request should be accommodated. Mackenzie did accommodate it. He called for backup and waited. What she did while waiting is what mattered. She didn't comply. She didn't provide her license. She sat motionless, her posture broadcasting dismissal, bathed in the glare of Mackenzie's flashlight as the body cam captured every second of it. There was no engagement, no attempt to de-escalate, no concession to the reality of her situation, just stillness, and the calculated bet that a superior rank of some kind would arrive and make this all go away. The footage from this stretch of the stop is almost difficult to watch, not because of anything violent, but because of how avoidable it all was. Mackenzie was patient. He was professional. He gave her every opportunity to turn this into a 10-minute inconvenience. She declined, repeatedly, in real time. When the supervisor arrived on scene, the dynamic shifted. This was no longer a deputy and a difficult driver. This was now a formal escalation, with a supervisor bearing witness to a continued refusal to comply with a lawful stop. The supervisor issued her what amounted to a final warning: comply with the officer's directives or face arrest. The legal authority for what came next is well established. In Pennsylvania v. Mims, 1977, the United States Supreme Court held unambiguously that a law enforcement officer may order a driver out of a vehicle during a lawful traffic stop, no additional justification required. The ruling applies nationwide. It applies to every driver, in every lane, at every hour. It applied to her. She was told plainly that her options were to cooperate or go to jail. The body cam captured it simply. She asked why she was being detained, to which the officer responded, "He was not detaining her, Colonel." He was, in fact, temporarily detaining her in the context of a lawful traffic stop, but the exchange reveals the absurdity of her framing. She wasn't being singled out. She was being stopped for speeding, like anyone else would be. She didn't get out of the car, and so the window broke. Deputies made the tactical decision to shatter the driver's side window, a use of force that, under the circumstances, was legally and procedurally justified. When an individual refuses repeated lawful commands and remains physically barricaded inside a vehicle, officers are authorized to employ reasonable force to effect compliance. The Fourth Amendment permits this level of force when the detainee has demonstrated clear and sustained non-compliance with lawful orders. She had done exactly that for the duration of the entire stop. The moment the glass gave way, the footage captures something that no amount of military bearing could conceal: shock. Pure, unguarded shock. For all her composure during the preceding minutes, the stillness, the window cracks, the demands for radar readings and supervisors, she did not believe they were going to break the window. She was wrong. Deputies reached in, unlocked the door, and physically extracted her from the vehicle. She was placed under arrest. The uniform didn't protect her. The rank didn't protect her. The law doesn't bend for either. On the curb, in handcuffs, she asked for her phone. She wanted to call her military commander. It is a request that reveals, more than anything else in the footage, how fundamentally she misunderstood the jurisdictional reality of what had just happened. A military commander, even a general officer, has zero authority over a county sheriff's department. The Posse Comitatus Act, 18 U.S.C. 1385, exists precisely to separate military authority from civilian law enforcement. Her chain of command could not override the arrest. Her rank could not undo the handcuffs. The Air Force has no jurisdiction over a Florida traffic stop. What she was hoping for, presumably, was some kind of intervention, a phone call that would straighten things out, smooth things over, remind someone who she was. But the deputies on scene already knew who she was. They knew she was a colonel. They also knew she was a motorist who had been driving 23 miles per hour over the speed limit, had refused to produce her license, had refused to roll down her window, had refused to exit her vehicle after a Supreme Court-backed order to do so, and had necessitated the use of force to be removed from her car. Her rank was irrelevant to every one of those facts. With her vehicle being towed, deputies conducted a standard inventory search and found bundles of cash. The legal distinction here matters and is frequently misunderstood. An inventory search is not a criminal evidence search. It is an administrative procedure authorized under South Dakota v. Opperman, 428 U.S. 364, conducted to document the contents of a vehicle before it is impounded. It protects the agency from liability for missing property. It protects the vehicle owner from theft. It is not triggered by suspicion of a crime, and it does not require a warrant. Whatever the cash represented, and that question raises significant ones, its discovery was entirely lawful. Deputies were not rummaging for evidence, they were doing paperwork. The fact that the paperwork turned up something interesting is not a violation of her Fourth Amendment rights. It is the inventory search working exactly as the Supreme Court designed it to work. The presence of that cash elevated an already complicated situation into something that would follow her far beyond the shoulder of that Florida road. When deputies asked her to submit to a chemical test, standard procedure following a DUI investigation, she said she needed representation before answering. That conditional refusal triggered Florida's implied consent law, codified under Florida Statute 316.1932. Implied consent is not a technicality. It is the legal bargain every driver accepts the moment they obtain a driver's license and operate a vehicle on a public road. By driving, you have already agreed implicitly under statute to submit to chemical testing if a law enforcement officer has reasonable cause to believe you are impaired. You can decline, but the refusal itself carries automatic consequences: a 1-year administrative license suspension for a first offense and 18 months for subsequent refusals. The suspension is civil, not criminal, which means it cannot be fought with the same constitutional tools available in a criminal case. It is nearly automatic. It is nearly unbeatable. Her request for representation before taking the test is treated under Florida law as a refusal. The moment those words left her mouth, the suspension clock started. No lawyer could undo it. No commander could intercede. No rank could reverse it. She had driven 63 miles per hour in a 40-mile-per-hour zone, refused every lawful directive issued to her, necessitated the use of force, and now had surrendered her driving privileges, all on the same night, all captured in high definition, all time-stamped for the record. The body cam doesn't forget. Neither does the law. So here's what I want to know. What would you have done in that car? Would you have rolled the window down, handed over the license, and taken the ticket? Or would you have held your ground the same way she did? Drop it in the comments. And if this breakdown had you locked in from start to finish, share it, because a lot of people genuinely don't know what the law actually says until they're sitting in handcuffs, finding out the hard way.